the recording, okay, and we'll just keep our fingers crossed as to the bandwidth. Okay, so this is our first topic. So civil law versus common law. So common law systems here are your, generally all the British colonies. Okay, so from here we have developed the common law system in all these countries. Now these are the first letters of the All right. Okay. So the first letters of the SWIFT codes for these currencies. Okay. So this is British pound, the US dollars, Canadian dollars, Indian rupee, Australian dollar, New Zealand dollar. So if you see so these are the countries. Okay. So now what is the and these are actually civil law systems are found in the European continent. Okay. So continental Europe. So France, Germany, Italy. Okay. D is for Deutschmark. So that's the German code, okay. The code for German websites you see is .de. So essentially what happens, the main difference between the two is the relative importance of judicial precedent, okay. In the common law systems, this has tremendous importance. In the civil law systems, the importance is not so much, okay, of judicial precedent. So mainly they rely on what is called the codified law. The codified law is essentially like your Indian Contract Act or your Indian Transfer of Property Act, okay, or Registration Act. These are all examples of what we call codified law, where the Parliament has made a law and this is written down and it's codified. So that's the codified law. And then you have the judicial precedent, which is basically the previous decisions of the courts. Okay, so in the common law systems, we give a lot of importance to this, and we apply these to decide many cases. All right. So this is the main distinction between civil law and common law systems. But in common law systems, we actually call them mixed systems today, because actually they are not just using pure common law. Okay, this was happening in the old days in England before they had a parliament, and they used to function purely on pure common law system used to be in England, where they used to be basically just the decisions of the judges, because there was no codified law, because there was no parliament. It was just the king sending his judges around the country. So the whole thing started from the days of little bit after William the Conqueror started the whole English legal system. So that is 1066 AD. That was when he invaded England. And then you had the Norman conquest of England. So that's when it started from. So it's very old. And then, so right now we have, like India today would be called a mixed system, because we are referring to both codified law and judicial precedent. Okay. So we are deciding cases based on both. Okay, so previous decisions. So that's why we call it a mixed system. It's not a pure common law system. Right. So codified law will include amendments. You can hear this term. You know, so like Citizenship Amendment Act. That's an amendment act. That's an amending act. Okay. So sometimes Parliament will pass these kind of amending acts. Okay. So the 2 points we want to learn about amendments is there are 2 new words we want to learn: prospectively, okay, and retrospectively. 2 words we want to learn. Okay, prospectively means in the future. Okay, so if I make a rule that everybody has to carry a laptop, so whoever's carrying a laptop, not carrying a laptop today, I'm not going to penalize them today, because I've just made the rule. So it applies from tomorrow. Okay, so it is prospectively. The rule is applicable prospectively. So that's in the future. It basically comes from the word prospect, which is something you see in front of you. It's the Old English word, Old English use of prospect. Okay, so and then you have retrospect, which is basically looking backward. So there are many amendments which happen, which especially procedural type of amendments, which we call, like, there are clarificatory amendments. Okay, there's another term. If there is a clarificatory amendment, we normally say that it will apply retrospectively, but sometimes even other types of amendments will apply retrospectively. Okay, also some substantive changes. Okay, which are not just clarificatory, but even substantive changes. Substantive changes means actual differences in rights. So if I said that overseas share transactions were not taxable, let's say, assume. But then I make a law saying that overseas share transactions will be now, income on overseas share transactions will be taxable. and I make it taxable going backwards for last 20 years. So whatever you did last 20 years in overseas share transactions, whatever income you earned, all that you have to now pay tax on. Okay, so that's an example of a substantive change, okay, not a clarificatory change. So sometimes you have even substantive changes which apply on a retrospective basis. So this is one of the things that happened after the Vodafone case. UOI is for Union of India, 2012. Okay, the famous Vodafone case which the government lost in the Supreme Court. They won in the Bombay High Court, but they lost in the Supreme Court. And this case is actually still going on in the sense that the government is still trying to extract this money from Vodafone, even though they have, they have had to go to arbitration. It's a mess actually. So the way the government is handling it is not good. It's not good PR for India actually, to the extent that we want to attract foreign investment. So this thing is still going on, the story. But the important thing is that there were many substantive changes which were made, even with on a retrospective basis after this in the Finance Act of 2012, following this judgment. Okay. So a few things we learned here is the difference between common law, civil law systems, importance of precedent, that is previous decisions. Okay, previous decisions of courts. Okay, where is the precedent? Okay, so I should define judicial precedent here. Okay. So I'm not writing perfect English. So perfectly, I would have to write the current case. So the problem is when you have to write good English, you have to write the so many times that it becomes quite a pain. And that's what is required when you're writing for when writing is going to be tested. But I will not impose these standards on you for your lab exams and things like that. I just want to know that you have understood the point. Okay. So the previous decisions of courts that are applicable to the current case, okay, that's what is meant by a judicial precedent. This is a precedent because it comes before, and it is judicial because it relates to an order passed by a judge, an order in a particular case. So therefore, it's a judicial precedent which is applicable to this current case, that whatever you're fighting in the court right now. Okay. So this is the meaning of judicial precedent. Okay. Second point we have here is, so A1 is civil law versus common law. The second point is the hierarchy of, yes, Shashank?
So this point is not very much clear to me. Like judicial precedence is more important in which of the scenarios, civil law or common law?
No, it is more important in common law. Okay, in common law systems. So when common law systems first evolved, the pure common law system as it evolved in England, before they got a parliament, okay, before that there was not even any codified law in England. So this evolved as a pure common law system, which is basically completely based on the previous decisions of the courts. Okay, and this has spread to all the English colonies. Okay, like I mentioned, Australia, Canada, US, India, etc. And on continental Europe, you have a different system, which is a civil law system, which is derived from Roman law, okay, and mainly a heavy influence of Roman law, and also the Napoleonic Code in France and things like that. So it is very heavily focused on the codified law, the written down law and the acts which are there. So just to clarify, the judicial precedents, which are previous decisions of the courts, are here. You can see the answer to your question here. Shishant, is it clearer now?
So, sir, why in the initial slide, India is written in the example of common law system?
Yeah, because India is a common law system. We still call India a common law system, although it's actually now a mixed system. So, because in India, we follow the British legal system, okay? In the sense, there's no real difference in the way that the system functions in India versus Australia or the US, okay, or Britain. It's the same system in the sense that you have some codified law now, but you also have the tremendous importance of judicial precedent. And when you're arguing cases in India, Australia, Canada, US, UK, you will basically try to, of course, focus on the codified law, but also look at any judicial precedent which applies to your case, which can be used as a sort of a overriding principle. Precedent becomes an overriding principle, okay? that you say that I'll explain this once I explain what stare decisis is, it'll become clearer. But the idea, whatever we are calling judicial precedent now, the previous decisions of courts, the reason it's applied to India also, India is a common law system because we have inherited the British legal system. Okay, so we are not functioning in some traditional Indian Chanakya style system or something. We are following the British legal system. This is clear, Prashant?
Okay, sir.
Yeah. So we are following the British system now. So if you are trained as a lawyer in India, you can actually go and practice in England or Hong Kong. Hong Kong is another place, which is again British system because Hong Kong is a former British colony. So wherever they had colonies, it just basically transferred their legal system. So that's why. Okay. So all right. So judicial precedent, that's the first one. The second one is hierarchy of courts. Okay. This is a pretty simple one. I won't spend too much time. Hierarchy means only this, that if we launch your calc file, hierarchy just means that the Supreme Court is above the High Court, the High Court is above the district courts, and even in the district courts, if you see, there are different levels of judges. Okay, there's a junior division judge, there's a senior division judge, then there's a sessions judge, etc. So there are all kinds of, even within the district courts, there are actually there's a further hierarchy within the district courts. So you can read this. There's a presentation here. I'm not going to go through this because this is just in the nature of information. Okay, so I generally don't want to waste class time where there's nothing to be, no conceptual matter to be explained. Okay, so it is just information. You should be aware of it. So you can just read this presentation and get yourself informed. So this is what is meant by the hierarchy. Okay, so here you have Supreme Court, High Courts. You have all the different High Courts, and you have the district courts. Okay, and so this is, we had a discussion in the other class. We had a discussion about for spoken English to track this guy. He's a very good speaker. So we'll do that later on when we come to that. Okay, so this is your second point. Okay, on hierarchy of courts, you just read this slide and you don't have to memorize any stuff. I just want you to give you a feel for it. Okay, so here I'm not going to ask you like which court is above the civil judge, junior division, and all that. I'm not going to ask you these kind of questions. Okay, so these are information type of questions. I'm not going to ask those. I will ask questions which test your concepts. Okay. Okay, so you can read this also. If you want to get a better idea, you can read this. This is also in your folder, the student folder. And okay, now here we've got, this is the idea of judicial precedent. This is called stare decisis. Okay, so this pronunciation is stare decisis. Okay, so that basically means that whatever is decided here, this one basically. Okay, this is the phrase, the Latin phrase. You don't have to remember the Latin phrase, but just remember stare decisis, which means basically that when a matter has already been decided in a particular manner, when that matter comes up, when a similar matter comes up again, okay, then in that case you should decide the new matter also, which is similar, in the same way that a previous matter was decided. Okay, so you can see straight away that this will have an impact. This has something to do with consistency. So we will discuss this shortly, but this is what stare decisis basically means. Unless, of course, we are giving a little caveat here, unless one is able to distinguish the case. So we will see what is meant by distinguishing. Okay, so unless you're able to distinguish the current case, which means showing either a difference in material facts or prove that the precedent is too wide in scope. Okay, so this is the two types of distinguishing. Okay, which we will just highlight here a little bit, and then precedent is too wide in scope. These are the two types of distinguishing. Okay, so we'll come to that, but the definition of stare decisis itself, we are saying that if it's a similar matter, let's say on similar issues, okay, because this is the point that we use in the case analysis. The point of issues means what is the conflict about? Does the house belong to Ankit or does the house belong to Vartika? They are fighting over it. So the issue is whether the house belongs to Ankit or Vartika. This is so if there is a similar issue, like a similar conflict that the court can find from its previous judgments, where the circumstances and material facts are the same, then they should apply that previous decision on that case. Okay, so this is basically the rule, unless, of course, you can distinguish the current case from the previous case that is being sought to be applied. So stare decisis, you can see this, okay, that judicial, generally we should follow this, okay. So you have clarity, okay. Clarity, the value of stare decisis obviously is clarity regarding, if you look at the value of stare decisis, this is clarity regarding interpretation of laws, okay, and certainty for businesses and citizens, okay. Obviously, that if we know, for instance, that if there is a ruling in tax law which says that any unrealized profits shall not be counted in taxable income. So you could have all kinds of unrealized profits in your property, or you could have your shares which you have not sold, okay. So all these kinds of unrealized profits, if we know for sure that these are not taxable until you actually sell it, then this gives businesses some kind of clarity, and they can actually plan based on this. So for instance, in the American tax code, you don't have to pay tax on your overseas profits unless you bring it into the country. So therefore, they have made some changes on this for this in the last tax act, which the Trump tax cuts. They made some changes, but essentially what was happening is a lot of these big American corporations like Apple, Google, Amazon, etc. They were they were basically parking billions of dollars, of profits overseas, in order to avoid the American tax. But because they brought it into the U.S., they'd have to pay tax on it. So these kind of things. So the point is that business planning is requires certainty a lot. Okay, so therefore, the value of stare decisis, because you're deciding cases similarly, it provides certainty for businesses and citizens. You have clarity regarding the interpretation of laws. Okay, so like if I said, if there is a rule that unrealized profits will not be taxed, then again, this is again giving you clarity and certainty for businesses, which are very important, actually, tremendously important. As you can see, so the whole English legal system actually has developed in many ways, because as you know, the English have been a spectacularly successful trading nation. A tiny country like that built a global empire just on the basis of trading. And of course, they had some strength. The English Navy was also a very strong, tremendous, very potent force. So all this. So one of the reasons why the English courts have been, English law has spread around the world so much, is that the English courts have been very conscious about this connection between, giving consistent decisions, and the English courts have tended to be very formalistic. When we discuss formalism versus realism, they are very, very strict. They just go by the language of the contract. Okay, if you have agreed to certain things in the contract, then later on you can't come and say, I want to change this and that. They're very, very formalistic in their decision making. So this is all connected to a culture of basically promoting business. So English courts are very business friendly. They understand the importance of certainty for businesses, okay, and clarity on the interpretation. So they have ruled in that manner. So that's why English law has actually spread around the world. And today you find, even in transactions like most derivative transactions, many financial market transactions, many capital market transactions, all are governed by English law. So you might have actually Citibank in Hong Kong dealing with Westpac banking in Sydney. Transaction in interest rate swaps, but the transaction will be governed by English law, and if there is a dispute, it will be settled in the courts of London, so in the English courts. So this is where the value of the evolution of English law, and it's also related to the idea that the English courts are very, very business friendly, and they're very professional. Then so that's everybody wants to go and have their disputes adjudicated under English law. So this is an important connection to understand, because when our again coming back, because everything at the end of the day relates to economic policy, economic performance. You have your entire lives ahead of you, and your economic prosperity depends a lot on how the economy is doing. Your own prosperity will depend on how the economy is doing. And that is also connected to the legal system, how quickly we can provide decisions, etc. Okay, so one of the things I discussed in the other class was this idea of it's a term that you guys need to learn. Okay, as a business student. Okay, Consistency, you can see stare decisis leads to consistency in decision making, okay, from the judge's point of view. And certainty is again good for business. There's a term called animal spirits, okay, basically refers to business sentiment. Maybe not just business, but business sentiment plus also retail consumer confidence. Okay, so maybe I should mention this also because it is in many countries, like the US, for instance, such a big economy, the biggest economy. Consumer spending is about 60, around 2/3 of the whole economy is consumer spending. So basically, animal spirits relates to both business sentiment and consumer confidence. Okay, so now here these are basically when we say that these are very strong. Business has very positive sentiment, very upbeat about economic prospects. So obviously, what they will do is they will invest a lot when they have a very positive outlook on the economy. And so consumer confidence also has a big impact because if you're very confident about keeping your job and getting a raise and getting a bonus, then you're likely to spend more. So this generally has a positive impact on consumer spending, which again has your GDP goes up, etc. So generally, business confidence, consumer confidence are very important in driving economic activity. So this we call animal spirits. So animal spirits are buoyant when these guys are feeling good about the future. It's very important because actually you'll find that in economics, although they use a lot of mathematical modeling and all that, it's basically just all useless stuff. I mean, when you really look at the real world, all that mathematical modeling is there's no real effectiveness in terms of actual predictions, precise predictions. The only thing you know about economics is basically that it depends on this. Okay, if the general sentiment is good, the economy will do well. And what actually affects the sentiment is very hard to understand, and it certainly cannot be understood by using mathematical models. Okay, that is a very, very misguided approach to trying to understand economics. But maybe the people who do it, their objective is not to understand economics, but to really publish papers in journals. So this may be a different kind of focus. So therefore, so this is very important. The point I'm trying to emphasize here is that this stuff is very hard to understand. I mean, it's like making a baby, it's like you can't force a baby to smile. You can force a baby to cry, you can make a baby cry, but making the baby smile is much harder. Okay, so when the baby wants to smile, it will smile, otherwise it won't. So understanding what makes an economy tick and animal spirits be buoyant is very difficult to get a fix on it. Okay, but generally if you have pro-business policies, low taxes, less regulation, that has an impact. So all these things are so what we had discussed in this context is, just briefly, we had discussed that many people, like in India, we have a very complicated tax code. Okay, so like Harish Salve, who's a very famous lawyer, and he had suggested, and many people have suggested, a tax on book profits, okay, to simplify the tax code. Okay, and so one of the proposals is to simplify the Indian tax code, because right now what happens is a lot of the disputes that happen in taxation today is in tax law, the disputes are related to, it's a useful thing to understand because tax law is, where is the part which I had written? Yeah. So the point is here that the dispute, actually what happens is a lot of the, I had written that somewhere. I'm just trying to find where that is. Yeah, never mind. I'll just say it. The point is basically that today, what is the value of a tax on book profits? Is that a lot of the tax disputes that happen today are related to let me write it here. Okay, many current tax disputes. This is an important thing to understand because it has it's related to your business law topic, and it is a very real issue in this country. That's why you notice the government has now started something called a direct tax Vivad se Vishwas scheme, where they want to settle all these outstanding tax disputes. Okay, so many current tax disputes relate to determining, there is something called taxable income. Okay, what is your taxable income? So if I earn like, maybe if I earn 20 lakhs, and if I have 5 lakhs as allowed as a deduction in investing in bank FDs or whatever, then my income is 20 lakhs minus 5. My taxable income will be 20 lakhs minus 5 lakhs. So it'll be 15 lakhs. And I have to pay tax on the 15 lakhs. So the point is basically the many tax disputes are focused on what is the taxable income, because sometimes they want to take deductions on certain matters, and then the assessing officer says, no, this is not allowed as a deduction. So most of the tax disputes are related to these kinds of issues. So what is the tax allowed deduction? So basically, in a roundabout way, what is the taxable income? We don't know what it is, because that's what people are fighting about. The assessing officer wants to maximize this, and the assessee obviously wants to minimize this. Okay, the assessee is the guy who's paying the tax. So now what will happen is, if you have a tax on book profits, now book profit, whatever the company is declaring, okay, if it's a closely held company, whatever you have, your accounting profit that you declare every quarter, okay. So then in that case, what happens is, if you just have a flat tax rate on whatever profit is declared, and you pay tax rate on that, okay. All right. Now, this is basically, this gets rid of this problem of, today you have so many hassles about determining, so many controversies about determining this, okay, taxable income. This takes care of it. Now you say that book profits are your taxable income, okay. Now what might happen is this, Tanuj was saying in the other class, that people will under-declare profits, okay. Now the question is, will they under-declare profits? Think about the incentives here, okay. Actually, what will happen is that, because businesses have an incentive to declare maximum profits because of the need to attract future investors and funding. And this, you could say that public companies have a greater incentive, but even private companies have an incentive, because if the incentive really does not change much between whether you're, between a public company and a private company, because everybody wants to grow. If you assume that everybody wants to grow, okay, then here we have, say, since all companies want to grow, okay, want to grow. So if you want to grow, you need more funding to grow, okay. So, and therefore what you'll do is, you'll have to try and get funding from investors, equity and debt investors, and all these guys want to see that you are making some money, right? So if you show to your investors that, if you're a public company, obviously you're declaring certain profit, okay, and that will attract investors to your company. And if you're even if you're a private company or a small startup, you also want to get money from venture capital funds and things like that, right? So like we saw, somebody has just taken a stake in Big Basket. I don't know, some very big company has taken a stake in Big Basket. So I forget the name, big international company. So these guys, why did they take a stake in Big Basket? Because Big Basket must have shown them in their financials that they're making some kind of money, or they have some kind of other viable business plan. So the point is that, even although it might seem that if you have a tax on book profits, companies will under-declare book profits, but that's not really the case, because companies have an inbuilt incentive to declare maximum profit, because otherwise they will not get funding. Okay, so you can still have problems, of course, auditors, but auditors are also there to act as a check on bad accounting. Okay, so therefore auditors are also incentivized. Like you see, Pricewaterhouse has been penalized for what they did in the Satyam computer case. Then in the US, actually, you had a firm called Arthur Anderson, which basically just disappeared. They just went bankrupt as they were involved in the Enron fraud, and they failed to check it. And so they failed, and that firm basically just disappeared. Hundreds of people lost their jobs. So auditors also have an incentive to check false accounting. So there are incentives built into the system which ensure that if you have a system like this, it's not necessarily true that the companies will under-declare profits in a systematic way. Okay, so this will solve the big problem of determining taxable income. This has become, because once you determine this, the tax rates are very clear, right? 35%, 25%, whatever it is. So once you know the base, once you know the amount to which it is to be applied, calculating that percentage is not difficult. The problem is determining this, because people are fighting over what is the right deduction, whether this is income or not. Okay, all kinds of hassles. So you fix all those problems by looking at this. So this is an example of a proposal where you're talking about, of course, we are talking about stare decisis. Okay. Not really so much about the tax law, but we just got into this discussion about certainty for businesses and the important idea of animal spirits, which you should learn. This is a term that you can use in your discussions. Okay, animal spirits. And then we talked about this system. So I thought we should discuss it here also, that you're aware of this term. So this was used by the English economist John Maynard Keynes in his book, General Theory of Employment, Interest and Money, the major book in economics. This is not very mathematical, by the way. In those days, they didn't use all this mathematical stuff. This was in the 1930s, 40s kind of time he wrote this book. They didn't use that, but although this guy is a very accomplished mathematician, this is not a very mathematical kind of book. Okay, so modern economics has become very messed up, but the earlier economic writers were quite insightful. Okay, so Keynes is associated with a term called Keynesian policies, which is generally given to any program for government stimulus to revive the of moribund economy. So kind of like what we are doing today, because of the COVID problems, the government is trying to put in a lot of stimulus. So in a way, you could say that this is also loosely termed as Keynesian policies, essentially used to justify lots of government intervention in the economy. Okay. So another point we discussed is that I've already told you that generally you have buoyant animal spirits when there's low regulation. A big factor, low regulation. Okay. And high certainty about what the laws are and how the laws will be applied. This brings us back to the idea of stare decisis. Okay, consistency in applying the laws, consistency in deciding similar cases. So that's a stare.
So,
Yeah.
so if I've understood stare decisis right,
Yeah.
it says that we take a decision based on the past decisions taken on the similar issues, right?
Yeah.
So, sir, how have we connected it with animal spirit and consistency in Texas? That I'm not able to understand.
Okay. So it's a valid question. Okay. So the idea of stare decisis is connected to certainty for businesses and citizens. Okay, everyone who's subject to the law. That part is clear. Okay. So this idea of good for good business, it creates a good environment for business because there's consistency and certainty. Okay. So what I was trying to say here, the connection to animal spirits is that when you have a regime which promotes consistency and certainty in terms of the interpretation of laws, etc., and businesses have certainty about what will happen in particular cases, then this is good for business sentiment. Okay, and because there is this term which is animal spirits, which refers to business sentiment, and actually not just business sentiment, also consumer confidence included in that. Okay, all the economic agents, their confidence level of economic agents, because this basically, when you say good for business, what does it actually mean? That business will have a positive outlook on the future and they will maximize their investments, etc., and spending. So therefore so that basically means that animal spirits would be buoyant. So I wanted to take this opportunity to, because we are very close to this idea that when business good for business means business sentiment will be very good. And another sort of a term of art that we have in economic policy, which is animal spirits, which essentially refers to business sentiment and consumer sentiment. Okay, so I wanted to take this opportunity because it is very closely related to introduce this term. Okay, and then of course we had discussed, for some reason we discussed this. Again, this was related to this idea that I gave an example of how you can use policy to improve the business climate. And so one of the proposals that has been discussed is the tax on book profits, with the example of India, because in India we have a very complicated tax code. Because what it does is, a highly complicated tax code is actually a disincentive for foreign investors. Okay, because right now we need a lot of FDI, but we're talking about make in India and all that. But the tax, not only is the tax law system, the tax code is very complicated. And it's also the tax administration is still not very professional. And we are still trying to, engage in tax terrorism and things like that. So it's not very good PR from the point of view of attracting businesses. So from that point of view, again, related to the larger idea of business sentiment, okay, and in everything I try to connect it back to the Indian economy, the current state, of the Indian economy, and that's why I discussed all this. Does that make more sense now, Krishan?
Yes, sir. And sir, one more question.
Yeah,
So I just wanted to clarify, stare decisis will be applicable in common law systems, right?
correct.
Okay, sir.
So it is written here. When you go through the notes, you'll find that it is there in common law systems, which is the yeah. So judicial precedent is basically stare decisis. Okay, the doctrine of precedent. Okay, in common law systems. Okay, all right. So okay, so this is basically it. So the discussion. So this discussion is important because it's a policy discussion, and one of the things that you should be comfortable with is having these kind of policy debates, arguing this side and that side of a policy position, because these are the kind of things that MBA students should be able to do. Okay, not just to repeat what is in a book, but also to be able to have these discussions. All right. So even everybody has an incentive to report profits properly, okay? Because otherwise you won't get funding. All right. So that takes us to our next topic, which is a subtopic actually under stare decisis, which is vertical versus horizontal stare decisis. So this is pretty simple. If you remember, once we had discussed earlier that I could not remember the article at that time. So this is article, vertical stare decisis is when higher courts will bind lower courts. Remember, stare decisis says judicial precedent, which means you have to follow that precedent, so you have to decide in the same manner. So you are bound by that decision. Okay, so that's what we mean by vertical stare. The higher courts will bind the lower courts. So here you have, this is actually here. Okay, so you have Article 141, where it says that this somebody was asking, I think Sushant himself was asking once, that law declared by the Supreme Court is binding on all courts, right? So whatever the court decides, until it is set aside, then it will be binding on all courts, because of course the court is here you can see the Supreme Court is above all the other courts. Okay, so it is vertical stare decisis, and Supreme Court is binding the Delhi High Court or the Calcutta High Court. This is an example of vertical stare decisis because it is applying vertically. Okay, that's why we call it vertical stare decisis. So stare decisis because the doctrine of judicial precedent is being applied, which means a previously decided case on a similar matter is being applied to decide the current controversy, and so we don't have to actually rehash the whole discussion. We can just decide it according to the previous case, right? So there's vertical stare decisis, and there's also the horizontal stare decisis, okay, which is this is horizontal is court to bind itself, the power of the court to bind itself, okay. So for instance, the Delhi High Court can bind its own, bind itself, okay, which is that because we also want that the Delhi High Court itself will should also decide cases if there is some kind of a case which the Delhi High Court, like maybe 5 years ago, there's a Delhi High Court decision on a very similar matter which is being argued today. Then even today's decision on that particular case should be along the lines of the decision that was given about 5 years ago by the Delhi High Court itself. So the court itself also should be consistent with its own decisions, okay? Unless, of course, you can show that there was something wrong with that earlier decision. In the discussion, it can come up, and then you can address that issue. But otherwise, in general, you are bound by it. So, especially when you have what is called a coordinate bench. Okay, coordinate bench means like the number of judges is the same. Okay, so if you have a Delhi High Court, if you have like a 3-judge bench of the Delhi High Court, then if they have taken a decision and then coordinate or higher benches. Okay, so either any bench further down the road in future years, which is 3 judges or lower, that will have to follow that decision. Okay, if it's a higher strength bench, then they can overrule. So this part is written here. You can just go through it. Okay, there is a bit of a write-up on Subbarao as to the details of how it works. Okay, but this is basically it. That generally the court will also try to be consistent with its own. You don't want the Delhi High Court to keep jumping here and there on the same issue. And so you want them also to be consistent with their own decisions. So this is what is called horizontal stare decisis. Okay. vertical and horizontal stare decisis. That's your second point. Okay, and then you have another point actually. These are topics. Okay, which is binding precedent versus persuasive precedent. A binding precedent one just has to follow. Okay, not really later court. So very often we write English like this, but if you are very strict, what happens is, which the court in the later case, okay, it's not the later course, but the court in the later case. So very often we write like this. But if you're very strict, then you'll have to write like what I've done, the correction that I've done. A binding precedent is one which the court in the later case is bound to follow. Okay? So this is a binding precedent. So once again, we can go to 141. Is to be binding. You see, the Constitution itself has used this kind of language. Law declared is binding on all the courts. Okay, so it's every court should be bound by the decision of the Supreme Court on any particular issue. Okay, that's one. So it's a binding precedent. Okay, and the binding part is related to the hierarchy of courts and the hierarchy of benches within courts. So, like as I said, within the Delhi High Court, like here, if you have a Delhi High Court decision, coordinate or higher bench, okay, it will bind the court bench. It will bind the bench in a later decision on a similar matter. So it is basically, so you have this concept of a binding precedent, okay, where the court is bound to follow, where the later case, the court in the later case is bound to follow. Okay, so if you have this, if you go back here, so if there's any decision of the Supreme Court now, you can say is actually it's example of vertical stare decisis, because as it operates on all the lower courts, it's number one, it's a case of vertical stare decisis. And number two, it is a case of a binding precedent, because as we see here in Article 141, the law declared by the SC will be binding on all the courts. Okay, so it is actually a binding precedent, and it is also a case of vertical stare decisis. Okay, that is applying this way. Right? So we can use both those terms for a Supreme Court decision. Okay. Now, there's also something called a persuasive precedent. Okay. Again, I've used court in the later court, so this should be changed to court in the later case, which the in the later case, all right, is not bound to follow, but it may still follow. Okay. Which the court is not bound to follow, but it may still follow. Okay. Maybe I could change the construction of the sentence a little bit, but that's okay. We'll just don't worry about that at this stage. So here's an example of a persuasive where you have, let's say, for instance, you have a court, you have a decision going on, you have a case going on in the Madras High Court, okay? And what they do, let's say it's related to the Madras Rent Control Act, okay? And because the rent control legislation that you find in India, in all the every state has a rent control act, okay? But they were actually all drafted, or they were all updated with, based on a certain model rent control act that the centre circulated. So you could actually, there are a lot of similarities in the structure of the state-wise rent control acts. So you could have a case in Madras going on, and the guy could, one of the lawyers could cite a decision of the Delhi High Court on the Delhi Rent Control Act, but we know that they are basically the same. That the basis is kind of similar. So this would be actually a case of this would be a persuasive precedent, because the Madras High Court is not bound to follow a decision of the Delhi High Court, because it is actually the same level court. So they are not allowed to. They don't have to follow their Madras High Court wants to follow their own decisions, but they don't have to follow the decision of the Delhi High Court or Calcutta High Court, right? But what might happen is, so they're not bound to follow it. It's persuasive. We say it's persuasive, okay? It persuades them, okay? Or it may persuade them. It's capable of persuading them, but they're not bound to follow it. So they may still say that, well, this logic is very good actually, so we will agree with the Delhi High Court decision. So the Madras High Court has the discretion to do that. So this we call a persuasive precedent. When you're citing a Delhi High Court decision in a case before the Madras High Court, that's a persuasive decision because the court is not, it's not a binding precedent. Okay, so that's another distinction that we are. So here, as I said, okay,
So,
yeah, yeah. Go ahead.
so can we say that persuasive precedents happen at the same level of hierarchy?
Yeah, you could say that. You could say that. Yeah, it happens at the same level of the hierarchy. Yes, you could say that. Not necessarily always true because, see, for I'll tell you why. Because sometimes what might happen is in a Supreme Court case, you have some kind of a novel matter where there's no Supreme Court precedent, where there may be decisions of different high courts. You could actually cite a case. So I just wanted to. Generally, your statement will be true in many cases, but it may not always be true because you could even have a case being argued in the Supreme Court where you cite a high court decision, which is actually a very good decision, very well reasoned judgment, and the Supreme Court might actually be convinced by that judgment. So that is also possible. So you could. It's not necessarily true that persuasive precedents have to be always at the same hierarchy between high courts. What you can say is that it is always true that when you submit, let's say, to the Madras High Court, when you are submitting a decision of another High Court, that decision is always going to be persuasive. Okay, that you can always say. That statement will always be true. But the reverse of that, that all persuasive decisions are of this kind of, in this kind of context only, that is not always true. Is this clear, Nishant?
Yes, sir, got it.
Yeah. Okay. All right. So here, now we have. Yes. Any question? Okay. So that brings us to our next question, okay, which is ratio decidendi. All right, next topic actually, not a question, but ratio decidendi. Okay. So when we have been talking about the rule of judicial precedent, stare decisis, okay, binding, all kinds of precedents. So what we are saying is the previous judgment has to be followed, okay. But the question then, if you really get into the weeds, you start getting into the details, then you might ask this question is, which part of the judgment has to be followed, okay? Because the judgments are quite long actually. Sometimes they run over 100 pages. So which part of the judgment should be followed, okay? So here there is a little bit of a further rule, which is that either you use this for singular or this plural, we just use this, okay? So here there's something called the ratio decidendi, and we have something called the obiter dictum. So we'll just define what ratio decidendi is, and at this stage I would say you should actually go and look at your, I mean, you don't have to do, I mean, don't do it now, but because I'll be teaching you something else, so you just focus on what I'm teaching you right now. So you have students lab 21, okay. Under students lab you have notes, yeah, spring, yeah, this one, okay. There is a cases thing. There is a folder called cases, statutes, etc. So in there is actually an article by Glanville Williams, okay, called Learning the Law. So you can look, you should read this article. Actually, this is important. This is part of your reading, okay? So when I say various things, some things are optional. This is actually part of your reading. So, and in this article, you will find that I have done, so these are my notes, okay? So this is obviously the article is the author's writing, but wherever you see this kind of bold, I mean, capital, all caps writing, those are my notes and my observations to clarify things hopefully for you. Hopefully it doesn't make it worse. Hopefully I make it clearer than, you know, and not make it worse, more confusing. But this is where I've made my own notes, okay? So you can read, you should read this article, okay? And this you can do later on your own. Okay. In the meantime, I'll just cover and I'll give you an idea of ratio decidendi, and we'll come back. This is a very important principle in law, understanding the ratio decidendi of a case. So we will have many occasions to return to this topic. Okay, what is ratio decidendi? Yeah, one sec. There's some kind of a chat message. So. All right, okay. So Pawan has asked about horizontal stare decisis with the example. Okay, mic is not working. Okay. All right, now 1 minute. Yeah. Okay. So yeah, one second. I'll just explain that. So we go back to horizontal stare decisis. Yeah. Right. So horizontal stare decisis is the, as we said, power of a court to bind itself. It may be useful to look at this kind of a setting, okay, where you have, so it can even happen at the level of the Supreme Court. The Supreme Court would also want to be consistent, okay. They don't want to keep deviating just because they are the Supreme Court. And they also have to generally follow the previous judgments of a coordinate bench. So this rule that is there, okay, which is here, okay, this rule that here you can read this also later on, as Subbarao has explained, okay, that generally we look at a coordinate bench as a bench of the same strength, okay. So a three-judge bench of the Delhi High Court is a coordinate bench for any further case being decided by a three-judge bench, okay, or so that's a coordinate bench in terms of strength, okay. So now you see the horizontal stare decisis, power of a court to bind itself. So this could generally be, I gave you the example of the High Court, Delhi High Court, following its own decisions, okay, because the court also wants to be consistent as far as possible, okay. So now if you take the example, as I said here, now we can take an example even in the case of the Supreme Court. I can give you this example, a very famous case actually in arbitration in India, okay. So you can see here what was happening was, there was a case in relating to the Indian Arbitration and Conciliation Act. This case was called Bhatia International versus Bulk Trading. It was generally not seen as a very business-friendly decision, but it was a decision taken by a three-judge bench of the Supreme Court. Okay, so there's Bhatia International versus Bulk Trading. Now this decision actually remained as the binding decision for 10 years, okay, and then it came to another case where I forget the name of the new judgment which overruled this case. So that was a more positive, business-friendly judgment. Actually, that was also in the same year, I think, as the Vodafone tax judgment. So there, and it's also by the same justice. There is S.H. Kapadia was the Chief Justice who gave both the decisions. So, but before that, the point is that Bhatia International versus Bulk Trading was, if you take the example of horizontal stare decisis, it was a Supreme Court decision, a three-judge bench of a Supreme Court. So it would have, even it was there, it was the law of the land for 10 years, okay? And so every decision on arbitration that was connected to that set of facts, similar set of facts, would have come to the Supreme Court, and it would have been decided on the basis of that Bhatia International decision. So that would have actually been a case of horizontal stare decisis even at the level of the Supreme Court, because even the Supreme Court wants to be consistent and it will follow its own decision. So what happened was, the reason this rule, the way the rule works is, as you can see, if you see here, it says if he does not agree, he shall refer the bench to he's talking about a single judge, okay? A single judge shall not differ from judgment of another judge, which means basically single to single coordinate bench, okay? Don't deviate, okay? If he does not agree, he shall refer to a bench of two judges. That is basically either or he can refer it to the Chief Justice, okay? And the Chief Justice will decide how it is to be dealt with, okay? He will obviously give more than one judge. So when this matter came up, Bhatia International versus Bulk Trading, and this precedent was there for 10 years, and when the new case came up, okay, here what happened was it came up to a three-judge bench of the Supreme Court again, and the Bhatia International decision was also a three-judge decision. So when this in the later case, where I remember Justice Karchu was one of the judges. So what they did was they looked at the Bhatia International precedent. They saw that it was a three-judge decision, and they were also a three-judge bench, and they did not like the Bhatia International decision, okay, although it had been the law for 10 years. They felt there was something wrong with it, So what they did was they referred the matter to the Chief Justice. This is kind of like he does not agree, he shall refer to the matter to bench of 2 judges or to the Chief Justice. So it's the same thing happened, same level, same coordinate bench, okay, 3-judge bench of the Supreme Court, and they did not like the Bharatiya International decision, and therefore what they did was. I'm going to try and look up the the case that I can't believe I've forgotten the name of the case. But anyway, I'll just try to. That was the case that stood for many years. But anyway, it doesn't matter. It basically is a case that came up, the new case that came up, and then the 3-judge bench in the Supreme Court basically then said that. We can't do any. We don't like this decision. We can't do anything about it because we are bound by the rule of horizontal stare decisis and the coordinate bench. Okay, so we will refer this matter to the Chief Justice, and he set up a larger bench. I think it was a 9-judge bench, which decided, okay, that this would then be decided by a by a larger bench. Okay. It would be decided by a larger bench, and that's what happened. Eventually, the Chief Justice Kapadia gave the decision, overruled the Bharatiya International case. Okay, so this is basically it. So does that make sense, Pawan? Is it clearer now? Let's see what Pawan says, because his mic is not working. Okay, so we'll wait for Pawan to respond. But this is hopefully it is a little clearer. Okay, so Pawan says it's okay now, it's clearer. Okay, good. So then, yeah, so we'll look it up. I'll give you the name of the new case later on. This is an important judgment in arbitration, and arbitration is very important from a business point of view. So this is basically the meaning of horizontal stare decisis. Okay. So let's look at this idea of ratio decidendi. What is ratio decidendi? Okay, let's try to understand. So ratio decidendi is the part of the judgment here, which we said. So you can read the Glanville-Williams article. It deals with this definition. Okay, with my notes, you can read that later, but I'll give you an idea. So ratio decidendi essentially is the 1 minute. Sometimes the computer gets stuck. All right. Yeah, so previous one with only the ratio decidendi has to be followed. Okay, what is the meaning of what is ratio decidendi? Okay, so let's talk about this. Here is basically the material facts of the case. Okay, this is Glanville-Williams's definition. Okay, decision. Okay, on the case, material facts, decision, and how the decision is arrived at by applying or interpreting the law. Remember the separation of powers, the role of the judiciary is to interpret the law. Okay, so therefore the logic of how so this is also part of the ratio decidendi, the entire logic of how the material. So we'll come back to ratio decidendi many times and define it with respect to individual cases, then you'll understand better. But we'll start with this definition. That's the material facts of the case plus the decision that is arrived at in the case, and what is how are they arriving at the decision by applying the law. Okay, in what way do they interpret the law? Okay, so the logic of how the material facts, basically this is a better definition, I think. The bare minimum logic. Okay, this is also, when we say logic, we're talking about the bare minimum logic that is required to reach the decision. Okay, so we don't look at, so we try to look at the decision and we look at the applicable law and we try to figure out the bare minimum logic that is required to reach the decision. Okay, nothing more than that. Okay, and so anything more than this, whatever is not the ratio decidendi, that will become the everything else. Okay. Okay, everything else that is other than the ratio decidendi. We say other. So we use two terms, ratio decidendi and obiter dicta. Okay, everything else that is other than the ratio decidendi. Okay, is basically basically obiter dicta. Okay, whatever is not central enough to be part of the ratio decidendi, that becomes obiter dicta. Okay, this is another term which you have. Okay, so coming back to ratio decidendi is basically what is the rule being laid down in that particular case. That's basically what we say is the ratio decidendi. Okay, so it is connected to the material facts, it's connected to the decision, but it is also connected to how the law is being interpreted and applied to the material facts to arrive at the decision, because this will become the guiding principle for future cases which are very exactly similar on material facts. Okay, exactly similar on material fact, but not on actual facts. Okay, it won't be ever exactly similar on actual facts, but the material facts can be similar. Okay, so here you have. Here I'll give you an example of this case. Okay, so we have a famous case in Indian criminal law called Virsa Singh versus State of Punjab. Normally, I don't like the right state, or I don't like right Union of India, because it is understood. So Punjab is a state. So there is a case called Virsa Singh versus Punjab, where what happened was there was a fight between two parties, and this guy killed one of the other guys. So the murder trial came up, and it basically hinges on the definition of murder. Okay, which with one of the clauses in the definition of murder. And so there is basically a question that arose, was that the defense lawyer for Virsa Singh was saying that this guy did not actually directly kill the other person, but he inflicted a very serious injury. Okay, which injury is of such a type that it, in the natural course of events, it leads to death. Okay, so therefore, this is basically what was happening in the case. Okay. This judge was Vivian Bose, actually. So he said that no, if you look at murder clause for defining definition of murder, okay, then if you look at this part of the definition, it says that if you inflict if you do such things, which do such a thing where you inflict a serious enough injury which in the natural course of events will lead to death, that is also going to tantamount to murder. Okay, so in this case what was happening is this principle was laid down, that it doesn't have to be directly murder, but if you cause an injury which in the natural course of events leads to death, that will also attract the same penalty as murder. Okay, so this is basically the idea here. Okay, that so what happens in this case is that Vivian Bose is laying down the law in terms of he's establishing a precedent as to how similar kinds of cases will be interpreted, where there is a conflict, where there is a fight or something like that, and then somebody inflicts an injury. He does not directly murder that person, but he inflicts a serious injury, which in the opinion of the medical practitioner is in the natural course of events is likely to lead to death. Okay, so that itself will also be counted as murder. So this is an example of a ratio decidendi of this case, where it was essentially, you would say that the ratio of this case is that if you inflict, so what is the learning from this case? Basically, you can think of ratio decidendi as based on, if we study how the material facts of this case were taken, and the judge applied and interpreted the law to the material facts of the case, and arrived at the decision. Okay, if we look at this and we expect this to be followed in the future for similar matters, then what is the rule that can be extracted from this case that will apply in the future, which is going to be that if you inflict this kind of an injury, then that will also be considered as murder. Okay, so that is what would be the ratio of this case, a ratio decidendi, which we sometimes just for short we just say ratio. Okay, so this is the idea. Yeah, go ahead.
So when we are talking about ratio decidendi,
Yeah.
what cases are we following? Like, are we following legal realism or instrumentalism?
Well, realism and instrumentalism are very similar. Okay, so it's not here. It's actually this here we don't think so much about realism or formalism as such. This is a general principle that, if anything, you could say this is more like formalism, because you're trying to be consistent and try to follow the overall tradition and the customs of the court or the legal system. So you could say, if anything, it is closer to formalism. But here, the requirement to follow the ratio decidendi is not directly related to the difference between formalism and realism. Okay, but if anything, if you wanted to bring in that debate into this aspect also, if you want to talk about ratio decidendi, and if you want to talk about, because the question of ratio decidendi it arises in the context of stare decisis. Okay, so stare decisis says that you should be bound by your previous decisions, either at either vertical stare decisis or horizontal stare decisis. Okay, so that is the context in which ratio decidendi becomes relevant, because then you start asking, okay, I should be bound by my decision, but which part of the judgment? Is it the whole judgment, or is it only the ratio decidendi, leaving aside the obiter dictum, which is not part of the ratio decidendi? So therefore, if we connect your question, okay, so what we can say is, normally we have not discussed this in this connection, but it's a good point, that if you were to bring this up, you could say that ratio decidendi is connected to the idea of stare decisis, okay? And stare decisis is a kind of system or a principle which is closer to formalism than to realism, because you're being bound by your previous decisions, okay? So there is a certain kind of limitation on your freedom. And if you remember what happens in realism or instrumentalism, judges like to basically have their own, they want to have their own discretion be the most important reason in arriving at the decision, okay? They want to look at the facts of the case, and they want to decide, okay, what is the right outcome for this case according to me, okay? In that case, they will therefore decide. So the most important thing for a judge who believes in realism or instrumentalism is, what is my view on the correct social policy? What is my view on the correct economic policy? And this is what drives their their decision making in the main, okay? So to the extent that that is the case, I would say that these ideas like ratio decidendi, stare decisis, they are more consistent with formalism than with realism, because in realism, a judge does not want to be bound by all these kind of rules, okay? Although they should be bound, okay? The system requires them to be bound, but generally judges who believe in realism are, you could say, less disciplined in that sense, because they want to do in every case, they don't want to have any kind of limitations. They want to look at every case and decide what to do with this in each particular case. Does that give you some ideas, Sushant?
Yes, sir, got it.
So this is the thing. Okay. So ratio decidendi, as we said, is basically what is the learning, what is the kind of a takeaway from, you could say this is a takeaway, okay, in a loose way. You could say this is a takeaway from, what is the takeaway from this case? What is the principle laid down in this case, okay? What is the principle laid down in the case? That could also be the principle laid down, or the principle established by this case, or established by the manner in which this case was decided. Okay? This is basically it. So we'll come back to it many times, because it's an important thing. Actually, you have there are cases where there are in the Supreme Court, there are actually arguments where people are going back and forth arguing about what was the ratio decidendi of a particular case. Okay, so therefore it's not an easy thing to determine, and there isn't a uniformity of opinion on this. Okay, so this is a subjective matter. What is the ratio decidendi of a case, and which you will see that Glanville Williams also has referred to this matter, that finding a ratio decidendi of a case is an important part of the training, and it is, he has mentioned later, that this is actually a art, not a science. Okay, so this is a thing you have to, it will take some time to understand. Okay, so obiter dicta is basically everything else that the court is saying which is not connected to the ratio decidendi. Okay, remember this is also a very important aspect of the this is very important, the bare minimum logic required to reach the decision in the case. Okay, this is also important. Okay, that is what is the absolute minimum logic that you need to reach the decision in the case, and only that we will say is the principle established by the manner in which this case was decided. Okay, Only that we will say, nothing else. Okay. So this will have an example. We'll discuss it later once with the case which we mentioned earlier once in response to Soumya's question, which is Innovative Industries versus ICICI Bank, which is a insolvency and bankruptcy court judgment. Okay, we will discuss that once again. So obiter dicta is another term we want to have look at. Just anything else with the court is saying in the judgment which is not central enough, okay, to the decision to be part of the ratio decidendi. So that becomes obiter dicta. So obiter dicta is a residual concept. Okay, I hope everybody understands what a residual concept. So make a connection. Remember, when we want to study, we always want to study in a multidisciplinary way. So I will bring you to another concept, which is a residual concept. So obiter dicta is a residual concept. So you take the judgment, you strip out the ratio decidendi, and whatever is left is obiter dicta. Okay. So this obiter dicta stuff we are not supposed to follow. Okay, we are not required to follow this. So when you say all this stuff about stare decisis and all that, vertical and binding precedent and this and that, so all this applies only to the ratio decidendi. It doesn't apply to the obiter dicta. Okay, so the rest of the judgment, which is not the ratio decidendi, is obiter dicta, and we don't have to follow that. Okay, so sometimes people just say obiter. So we don't say ratio decidendi, we just say ratio, and for this we just say obiter. Okay. So obiter we are not required to follow. Obiter is a kind of a residual concept. You take the whole judgment, strip out the ratio, it's a residual, and whatever is left is the obiter. So something else which is a residual concept is net worth, okay, or basically we use slightly American term actually, owner's equity, okay, which is sometimes also in India we call it share capital and reserves. Okay. They're all, I'm referring to them as the same thing. Okay. Net worth, owner's equity, share capital, reserves. Okay. These are all also a residual concept. Okay. Just quickly recapping, quickly shaking your head up a little bit and forcing you to think about your accounting classes. Okay. And so this is what we try to do always, that we try to teach from a multidisciplinary perspective so that you see all the connections. When I mentioned the word residual concept, I remembered that there's something else in business which is very important to understand, that net worth is a residual concept. Okay, that so net worth could be either owner, I'll just call it net worth, but it could owner's equity, you can call it share capital reserves. So residual concept, why? Because the formula for net worth is total assets minus, okay, I'm writing minus like this, what we call outside liabilities. Okay, outside liabilities is a term that we use, and it's a finance term. So here, outside liabilities means essentially outside means outside the company. So liabilities of the shareholders, liabilities of the company to the people who are not the shareholders of the company. Okay, so in finance we call them owners, but in law we don't call them owners. So I'll use the finance term. So outside, because it helps you to understand outside. Okay, so usually when we write when we are discussing this 224. Okay, so what we do is we write the liabilities on this side. Okay, and we write the assets on this side. Okay, you can write it on whatever side you want. Okay, I learned it this way, so I write it like this. So if you have here, if we assume that here you have a debt of $100 and you have assets of say total assets is, let's say, $700. Okay, and then you have, so therefore your owner's equity is, your outside liabilities is $100. The bank loan, let's say this is a bank loan. So this is basically stuff which is all this debt that you owe to other people. Okay, even preferred stock should be considered as part of this. Okay, because we are talking purely about, in net worth we want to talk purely about the share capital. Okay, the equity shares. Okay, so outside liabilities, it should include net worth, preferred stock also. Okay, so all the debt you have to bank loans, this, that, long-term bonds outstanding, and then here you have your net worth. Okay, so the net worth basically gets written as this, is written as 700 minus outside liabilities. Okay, so this is basically your concept of residual. Okay, so now what happens is, if your assets, let's say your assets were a bunch of netbook computers. Now suddenly the smartphones are released and netbook computers business goes for a toss. So the accountant comes and tells you that all your network computer inventory that you have, that is all useless now. You better mark it down, and you better make it from 700. It is not worth 700 anymore. It is worth only 400. So your net worth goes from 600 to 300 because this one can't change. Okay, this is debt that you owe to outsiders. Okay, so just doing a quick recap on accounting. Okay, because some of you don't come from an accounting background, and sometimes I have seen even with finance students that they are not clear about their accounting. Okay, so please make sure this is a quick recap. Everybody understood what I did just now in terms of net worth being a residual concept with your all business students. Okay, maybe I repeated some stuff, but I hope everybody understood. Yes? Okay?
Yes.
Yes, sir.
Okay, great. Excellent, great. So maybe I was wasting my time doing some very basic stuff, but I just thought I'll just do it quickly because I have seen in the past sometimes people are not 100% clear. Okay? So you learned another term called the residual concept word. All right. Now here, this is a new term that we want to learn. It's called distinguishing. Okay, this is another topic. Okay, distinguishing. If you remember, when we went to the when we wrote down the definition of stare decisis, okay, what did we say? It's a doctrine of juris or precedent. Okay, those which are things are decided, stand by precedent, don't disturb settled points, etc. And we said that this is the doctrine of precedent. Okay, judicial means laid down by a judge. Precedent is came before, and so we follow. The doctrine says you follow the previous decisions of the judge. Okay, so and obviously on a similar matter, okay, similar issues in the case, okay, and unless one is able to distinguish, so we use this particular term of art. Unless one is able to distinguish the current case from the precedent. Okay, so we are talking about two different things. One is the precedent, and one is the current case. Okay. So what do we mean by distinguishing? As we said, there are two types of distinguishing. Okay. Either you show a distinct difference in material facts. Okay, this is also mentioned in the Glanville Williams book article, but again, it's not very well written actually. But so there's another source with material on this. But I think if you look at my definition, it should be sufficiently clear. So we've got two types of distinguishing to worry about. We will call them, so here one will involve difference in material facts, and the other is that the precedent is to show that the precedent is too wide in scope. Okay, so let's see if we can quickly run through these. Okay, let me also see whether I set your alarm properly. I didn't set the alarm actually. But so in this case, what I will do is I'll not set the alarm. I'll just monitor the time. I'll make sure that you don't get detained. Okay. So what we'll try to do is now we are learning. So what we are seeing is that going back to the definition of stare decisis, we said, yes, this is what you should do if the matter is a similar matter. But unless there's a little caveat here, unless one is able to distinguish the current case, one is distinguish a technical term, it has two types. There's two types of this. Difference in material facts, this we will call non-restrictive distinguishing. I've got the term written down. This we will call restrictive distinguishing. Now let's go down to the distinguishing part, because we are now saying that there is something called distinguishing. Okay, this is a very important legal, very important skill for lawyers. Okay, right? Because if you don't, because what will happen is in the common law courts, typically what happens is the judge, the advocates will present some arguments, and then they'll present some precedents. Okay, they'll present some judgments, which are precedents, and they will say that these judgments should be followed in this particular case. Okay, so they are invoking the doctrine of stare decisis. Okay, so if the court agrees with their view, then you're in trouble because the other guy is going to win the case. So you've got to learn how to distinguish, and if you are able to distinguish, then you will prevent this case from being applied. Okay, so there are two types: restrictive and non-restrictive. Okay, so we have these two types. Okay, restrictive and non-restrictive. Okay, right. Okay, so here, as we can just telling you why distinguishing is important. Okay, any case cited by any case cited by a lawyer is a precedent. It will be applied. Obviously, I mentioned this already. Okay. Right. Okay. So what are the two types of distinguishing? Okay. So the objective of distinguishing is basically to ensure that the other guy is citing a case, the other lawyer is citing a case, and you want to distinguish it because you don't want that case to be applied in this case, in this particular matter, because then that the other guy is going to win and you're going to lose. Okay, so you have to find a way to distinguish. Two types of distinguishing. Okay, if you can show a difference in material facts, okay, so for instance, if there is a case where show a difference in material facts in the current case, okay, so for instance, if the precedent that is being cited has two material facts, B and C, and in your case there are actually additional material facts A and D, then you can show that material facts would be like, say, for instance, that let's say there is a drunk driving case, that there was this guy was drunk and driving, and then he actually injured a pedestrian, okay, and the same thing is there in your case, but the problem is in this case that it would not have B in it, okay, so this is not a good example actually. So maybe we have a case, we go back to the Virsa Singh case where you have a fight between two parties, and there's a scuffle between two parties, and then one party gets severely injured, and that injury can lead to death, and that is being cited. And the same thing happened with your client, and there was a scuffle and there was some, but actually what you can show maybe initially is also there was something else that happened. Maybe they were on the scaffolding or something else fell, and so the injury that actually got inflicted on the other guy, which was a life-threatening injury, basically serious injury, but that happened because of some other fact. It's not that your client actually did it, but his something fell on his hand and the gun went off or something like that. So there are some other mitigating facts which are different from what was there in the precedent case. They are very important, that the gun got fired because okay, so in this case it is already 3 p.m. So I will not delay you. It's a 24 seconds past 3 o'clock. So I'll not delay you. So your classes, I'll continue this in the next class. Okay, so we are trying to what we say is that I'm trying to explain started with the explanation of distinguishing. Okay, I'll make this done. So the rest of you can go, and if anybody has a question, then I will not. So as a general rule, when there is any kind of a substantive question, a conceptual question, then I will not stop the recording. Okay, and then I will have that recording as part of the conceptual question. I mean, have the conceptual question as part of the recording, and then I'll stop it only later on. But the rest of the class is free to go. Okay. Please remember, please keep revising because you are going to be tested on this. Okay. And please form your groups. Next week, I'll come and address this matter. Okay. Please get your groups formed, 5 to 6 people max. All right. Anybody has any question? No? Okay. All right. So then I'll end the class. I'll just make a note that where we stopped. We stopped at distinguishing, just started. We talked about we started non-restrictive distinguishing. Keep a track because otherwise I get confused what I finished at in what class. Okay. All right, folks. So I'll see you next week. Okay. Please stay focused and try to maximize learning from this program. Okay. And take care. And I'll see you next week. All right. Okay. So I'll end the sharing. I hope I was.
Thank you, sir.
Okay. Great. So you can hear me. And yeah. Okay. So I'll stop the recording also. And I just wanted to make sure that